Welcome, everybody, to this, which is the first in our 2026 three-part webinar series dedicated to aspects of higher education and civil claims. And by our, I mean the 3PB team, and you have two members of that team presenting today's webinar, which is on higher education safeguarding issues and fairness in investigations and hearings. My name is Lachlan Wilson, and I have been a barrister at 3PB for over 25 years. I practice predominantly in education law and also in employment and professional disciplinary law. Presenting with me today is Alice de Coverley, who has, since being my pupil some years back, soared magnificently in the field of education law. She was counsel for Ofsted in the independent inquiry into child sexual abuse. And in addition to her education law practice, she also has a charities practice where she advises on safeguarding and discrimination issues for that sector. She has or will have shortly a chapter in Tolley's Charities Manual, soon to come out, on the Equality Act and its application to charities, particularly following the For Women Scotland judgment, which will be relevant to safeguarding issues. We are your presenting team today. I ought to have said it's Alice who will be moving the slides forward. So you may hear me say, next slide, please, Alice. What are we going to talk about? Well, here we are on this slide. I shall be looking at the types of harm that really inspires presentations such as this and scrutiny into areas such as this. Then Alice will take over and look at the policy landscape. And then we'll look together at the sources of duty. I'll focus on the common law duty of care. Alice will then look at the statutory landscape with particular regard to the anticipatory reasonable adjustments duty under the Equality Act 2010. And that some of you will be aware will follow the Abricot High Court appeal decision. Alice will also go into the potential for law reform, whether by the introduction of a new statute or simply improving on current regulations. And then Alice will look at some disciplinary process pitfalls, covered principally in the case of AB and XYZ University, and we'll finish on some safeguarding practice tips, the principal one being don't let GDPR breach anxieties prevent you from safeguarding a person's vital interests. And finally, we will have time, I hope, for questions. So please can I ask you to use the Q&A box and not the chat tab if you have a question, and then Alice and I will endeavour to answer as many of them as time permits. We aim to finish on the dot of midday, as we're conscious that many of you will have other commitments. But be assured that if you're attending today, you will have registered with your email address, and our Chambers Marketing Manager, Delphine, will ensure that you are all sent a copy of the PowerPoint presentation. So I'm going to begin by moving to the issue of the harms. And on this slide, I've set out a list of the harms where students have either been harmed because they've been injured or even died in extracurricular activities. And let me be clear, I don't mean extracurricular activities provided by the institution, because clearly a potential breach of duty of care may follow from that. I'm talking about extracurricular activities outside what would ordinarily be provided by the institution. The clubs and societies that may not, for example, be managed by the institution. Since the pandemic, there has been a focus on the avoidance of social isolation and a broader sense of the student experience and a recognition that students may be potentially vulnerable, particularly if they are away from home for the first time. We also have changing attitudes towards consent around relationships and sexual engagement. So most new students are now expected to attend talks and discussion groups on what's acceptable and underlining the implications around non-consensual activity. There is an evolution in approaches to what's required of students academically, and what an institution's duty of care here is to potentially vulnerable or at-risk individuals if the academic rigours may go beyond what the student may be capable of. And then finally, the Office for Students, and Alice will be covering quite a lot of the policy landscape surrounding this. but certainly intimating that more needs to be done, especially as regards mental health. So, for example, increasing the availability of counselling services, providing access to mental health professionals, and offering online resources and helplines. And some institutions have even introduced peer support programs and mental health first aid training. So that's the harms. And why are we there? Next slide, please, Alice. Well, here's one of the reasons why we're there. National Review of Higher Education student suicide deaths. 107 suspected suicides, 62 incidents of non-fatal self-harm during the 2023 to 2024 academic year. 169 incidents. And of course, what you may expect is the number of incidents of non-fatal self-harm is likely to be significantly underreported. So we're going to move now to Alice, who over the next few slides will take you through the policy landscape in the field of safeguarding.
Thank you so much. So on the next few slides, you'll see a number of different links to things that you will be able to click and look at in more detail once you receive a copy of these slides. But we thought it would be important for you to understand the kind of context that the higher education sector has to work in now generally, and also the kind of expectations in terms of best practice. And there is such useful guidance out there that we thought it would be sensible for you to hear about it. So on this first page, this is from the Office for Students, so the OFS. And as many of you will know, this is the independent regulator of higher education in England that was established by the Higher Education and Research Act. And it gives it the ability to regulate such providers of higher education. And it does that through registration conditions for registered providers. And that's specifically within section 5 to 7 of the HERA. And that gives us OFS, the power to register higher education providers and impose conditions of registration. So there will be those initial conditions that must be met to join the register. And then there are these ongoing conditions that must continue to be met in order to remain registered. And condition E6 is an ongoing condition. And as a headline, this is an ongoing condition of registration that came into force in August 2025, so relevant to things now. And it covers incidents of harassment and or sexual misconduct affecting students. That includes staff to student to student conduct, and applies across higher education courses provided on behalf of the provider. And what this means is that providers have to maintain a single comprehensive source of information, setting out policies and procedures on harassment, sexual misconduct, and staff-student intimate personal relationships. And that single source must meet minimum content requirements, content principles, prominence principles. And that means making historic versions available, being transparent about changes. And you can see how some of this feels like it might be inherited from the much higher standards that we are seeing in the school sector. The provider must then act in accordance with that published source of guidance, which will be then made available to students and to staff. And then there are other aspects of that that we'll be interacting with, for example, the free speech obligations as well that I'll come to. There are very specific expectations in terms of staff-student relationships, but it doesn't go as far as to say that there must be bans, but it says that a ban could be something that would make a significant and credible difference. So this is very important as a landscape for you to be aware of as a practitioner. And if you look in the detail of this, which is available through the link, you'll see that there's also restrictions in terms of preventing students from disclosing information about allegations as well. And so it hardwires those procedural expectations into regulatory requirements. It also has within it these requirements about training, as Lachlan has mentioned, about making sure that those who are conducting investigations or making decisions about harassment or sexual misconduct matters or providing support are doing that properly and throughout the process, throughout the investigation, and throughout the decision-making process. And so a breach of that may give rise to regulatory risk for a university. And it may also be something that you could hang a claim on as a practitioner. So the next bit is the guide on preventing and addressing harassment and sexual misconduct. So this is a guide. This is about explaining what that E6 condition requires in practice, has like definitions, policies, procedures. Also talks about things like non-disclosure agreements, freedom of speech angles, monitoring, enforcement. And so that again is also a very useful way of analysing the duty under that condition. And it also really makes clear that that report route and support has to be accessible as well, and talks actually quite helpfully about anonymous reporting and other online mechanisms to support pupils and to support students and staff. We've then got the statement of expectations. So this comes from a slightly earlier expectation from the OFS, which is prior to these new conditions, but it's very useful, I think, to see where the condition E6 then came from. But it's a useful context for how the sector got here. And if you're looking at older disputes, then have a look at this earlier policy, which is about what was the position prior to the E6 used to come into place in August 2025. So it gives you the pathway to where we are with the current requirements. And good practice framework. So this is from the OIA. So the OIA, again, for those who don't know, that's the Office of the Independent Adjudicator of Higher Education, the OIA. That runs independent students' complaint scheme for England and Wales, and reviews about how you characterise as unresolved student complaints about providers. Usually where a complaint has gone all the way through the internal systems within a university already. And that's based on the Higher Education Act. And so the OIA is part of what was created out of that. And they have a good practice framework, and this is useful guidance to support providers to develop and follow fair processes, and as a tool to evaluate those processes. And this is how the framework is also how OIA will consider complaints as well. So you can quote it as a lawyer for a student as persuasive, good practice, an indicator of what the OIA is likely to regard as fair in terms of complaints handling, disciplinary processes. And that's it's explicitly how the OIA will consider complaints as well. So it's usually something that's worth quoting back. It's obviously not legislative, but it is very practical and very useful for you to be able to rely on as you need to. We've then also got other good practice in terms of disciplinary procedures as well, and you will come to some of the case law about that later in the talk. But this is going to use case studies and different examples of things like how to make sure things are procedurally fair, how to deal with something if you have to go back into investigating the same offence, how to deal with evidence that changes over time, reliability of evidence, how to deal with issues in respect of the severity of something, the impact of multiple processes on a student, what to do if there are concerns about the fairness of the process that was at first, how to remedy it in the second way around of trying to do it. And the case study structure is quite useful, I think, at helping to train decision makers in higher education settings as well, in how to deal with things in a proportionate way. And I say the same about the OIA handling complaints and academic appeals document as well. So this is all stuff that would be very familiar to you as lawyers, but the idea about making things fair, independent, confidential as needed, inclusive, flexible, proportionate, all of those sorts of things. It also has a good section on time limits. So why things, one of the main things that I would say probably both of us have had to deal with are cases that just drag on for years. And that can be such a big source of concern to students. So it does have some useful guidance on time limits and also on the Equality Act as well. So particularly relevant to things like late complaints, which might be as a result of somebody's disability, or whether reasonable adjustments might be reasonable to put into place for the process or for the fact of accepting a complaint late and so on. And the expectations about evidencing disability as well when requesting adjustments is actually also featured in here too. We then got the UK Universities UK guidance for higher education institutions. So this is useful if you've got cases where you've got a difficult boundary between misconduct and something that might be a criminal offence. So in here, I think you'll find that will obviously be relevant to cases like where there's a sexual harm angle consent issue as well. And that's where these case studies in the middle are really useful to look at too. So again, for practical training, scenario testing as well, looking at different fact patterns and what you would do in different scenarios. So again, you could use these things for framing pre-action correspondence. You could also cross-check what a university has done with what others in the sector have done too. So I think that is worth citing at times as well. And then at the bottom here, we've got the staff student sexual misconduct strategic guide. I mean, the fact that we even have a guide on how to manage staff to student sexual misconduct is highly depressing, but it exists and it's important it does exist. And it's acknowledging, I think, the power imbalance within the student and teacher dynamic, and the idea that there might be conflicts of interest, but it also has this important angle about safeguarding risks, reputational risks, how to deal with it as not just ordinary HR or ordinary student discipline. It's a bit more much more complicated, I think, often as well. So that is again very useful for you as well as looking at best practice. Related to all of this will be freedom of speech. So a number of different cases that we've both been involved in touch on freedom of speech issues quite heavily. And the reason for this is because there is often a balance between what a student or staff member can say and the idea that that might cause harm of some kind to another student or staff member. And so the OFS guidance on providers' free speech comes under the Higher Education Freedom of Speech Act, which we'll look at a bit later. And so that again is very much worth having a look through. And this looks at about practical steps to secure freedom of speech within a university environment, academic freedom, and also looking at the convention right requirements on a university as well. And is very much an area of litigation risk. And if anyone who's been following it in the last year or so, but particularly in the last month, there was, of course, the University of Sussex. It was hauled up by the Office for Students in terms of how it dealt with Professor Kathleen Stock, and in terms of the sorts of things that were said during her employment and the interaction between her rights as a person and as a professional in that environment, and also the freedom of speech obligations as well, to say what she was saying, and also the kind of high stakes interface between inclusion, harassment, prevention, and so on, balanced against lawful speech and academic freedom. So the Equality and Human Rights Commission has put out guidance. I think this will probably update again following whatever happens with the challenge by the University of Sussex to the OFS decision to sanction the University of Sussex for how it handled the Kathleen Stock case. And I think it's probable that they will, the University of Sussex will succeed in that judicial review, but we will see. That was the fine that was given, very hefty fine to that university. I think it's probable we will see amendments to this particular piece of policy this year as well. But keep an eye on that. So, and then I've just added in here about the prevent duty as well. Not that common, I would hope that you would need to be able to touch upon this, but it does have some useful guidance on fair investigations and procedural risks and the relevance of the prevent guidance as well. And I think particularly with the Nottingham inquiry happening at the moment, we can see how professionals will need to make sure that they are thinking carefully about safeguarding risk in the kind of wider ecosystem of a university and the world that we're in. Then finally, I've got guidance in terms of the consumer side of things. And of course, just coming back to this point about how students are consumers, and that really matters for disciplinary fairness, because there are just such higher expectations of the students about what they should be entitled to for all of the money that they're paying for the education and the experience that they're meant to be getting at university. And we're seeing a much more increased angle on consumer rights legislation, consumer remedies as well. So it's very helpful, I think, for you to have a look at this particular guidance too, which will talk about different remedies and also the frameworks in terms of the OIA and the OFS as well. So there we go. All right, Lachlan, that was the wider policy framework and compliance framework. And then I think it is back to you for the sources of the legal duty.
Thank you, Alice. And in fact, that previous slide, the CMA guidance, does actually lead quite nicely into the sources of legal duty, particularly when one regards the student as a consumer. But on this slide, what I've done is I've tried to set out some of the available statutory and guidance sources vis-a-vis safeguarding as opposed to legal causes of action. And straight away, you'll see that there's a divide in guidance between children and adults. Some of the guidance being restricted only to children for whom the HE sector is not typically responsible. Albeit you should acknowledge that there may be scenarios brought to the attention of higher education staff that can involve children. So that's why it is sensible to be aware of the guidance protecting children as well. But higher education providers aren't subject to legal safeguarding duties in the same way that schools, further education colleges, local authorities and care providers are. And safeguarding and promoting welfare in relation to children is protecting from maltreatment, preventing impairment, ensuring that children grow up in circumstances consistent with the provision of safe and effective care, and taking action to enable all children to have the best outcomes. And of course, what we're dealing with is the move from childhood to adulthood. And by its nature and reflected in the statutes, that means some of those protections fall away. And safeguarding adults legislation is primarily about protecting vulnerable adults, adults who have been identified as vulnerable. So, for example, those in care settings or those who are not capable of managing their own affairs, and protecting them from abuse and neglect. And the specific legal relevance to HEPs, higher education providers, is likely to be minimal, except where medical and allied medical staff and students are on placement. It's worth bearing in mind that an adult at risk, sometimes referred to as a vulnerable adult, is defined as any person who is aged 18 years or over and at risk of abuse or neglect because of their needs for care and support. So there's no definitive list of who adults at risk are, because each situation needs to be considered on its own merit. But you'll see from that definition that it's quite a high bar. Now, as Alice has pointed out, HEPs are obliged to comply with some safeguarding-related legislation, for example, PREVENT. And that is statutorily enforced, and that places duties in respect of people, that is, children and adults. There is, under the Separate Leadership Foundation for Higher Education / Committee of University Chairs guidance, available on PREVENT, and you can actually access that separately. But also, under the Committee of University Chairs, that's the CUC Code of Governance, university governance have assumed a responsibility to receive assurance that adequate provision has been made for the general welfare of students. And by undertaking that responsibility, it is possible that HEBs are, well, it's not possible, it's quite probable that they're expected to make clear in all their marketing materials, student handbooks, for example, what services are available, whether it's counselling, pastoral support, and what support might be offered by HEP staff, such as personal tutoring. So while there's no clear definition of what welfare provision looks like in practice, HEPs do have a contractual duty towards students to deliver services, including any welfare or pastoral services, to a reasonable standard. So universities who subscribe to the Code of Governance will be expected to set out what it is that has been done to enable them to be assured that adequate provision has been made for the general welfare of students. Now, while those documents don't necessarily invoke contractual terms or constitute contractual terms, they do guide and are capable of guiding the extent of the duties and may touch upon whether or not a common law duty is deemed in the circumstances to exist. So it's very important that higher education providers are clear about the extent of the services they offer to students, particularly pastoral services. And as you saw from the CMA link above, that's particularly a particular requirement for consumer protection. If we move on to the next slide, and now looking at the sources of legal duty beyond safeguarding per se. And the first and obvious one is the tort of negligence, the general duty of care. I will look at that with you, and I will touch upon whether or not a legal doctrine of in loco parentis exists. Then Alice will look at the Equality Act and particularly the anticipatory reasonable adjustments duty, and we'll just mention the potential for law reform, whether that's statutory or beefing up the regulations that already exist. So moving on to the next slide. The general duty of care, this is just a reminder. It's a law school reminder of what we need to establish. Foreseeability, proximity. Are there any policy considerations which suggest it's not fair, just, or reasonable to impose a duty of care? Then you look at the standard of care and whether or not that standard has been breached, and whether then you look at causation in the last section there, section 5. That's just a quick reminder, and I give you that reminder because it's worth looking at those decisions which don't find a duty of care existing and compare those with those decisions that do find a duty of care existing. If we can move on to the next slide, please, Alice. So the general duty of care, the two important authorities I've set out there, the Robinson and West Yorkshire Police, that's a case where an assailant running from the police barges into a member of the public and causes injury to the member of the public. Now, was the police responsible in any way for the or liable for the injury sustained by the member of the public because of the way in which they gave chase or did not apprehend or failed to apprehend? And that case clearly established that no duty arises from a failure to prevent harm from third parties or natural causes unless a particular type of relationship or an assumption of responsibility exists. And you will be aware, I expect the majority of you, of the Caparo Industries line of authorities that talk about the requirement for an assumption of responsibility. The other case there is Tyndall and Chief Constable of Thames Valley Police. A person owes a duty of care to take care not to expose others to unreasonable and reasonably foreseeable risks of physical harm created by that person's own conduct. And the important point here is it has to be the tortfeasor's conduct that has created the harm before there would be sufficient proximity for the liability to flow. And that's not just positive conduct. So you see in the next quotation there, if A knows or ought to know that B is in need of help to avoid some harm, and A knows or ought to know that he has done something to put or prevent someone else helping B. So it requires some action on the part, but that could be not acting, but not acting in such a way as that prevents someone else helping B. Then A will owe B a duty to take reasonable steps. And so those are two important overarching authorities that really define whether or not the duty of care exists as between the complainant and the alleged tortfeasor. If you can move on to the next slide, please, Alice. Now, I've put the Aberhart first instance decision at the top here because at first instance, you'll see what was decided as far as the existence of a duty of care. I think we may all be familiar with the tragic circumstances of the student in that case, Natasha Aberhart, studying physics at the University of Bristol, and committing suicide. And her father brought the claim in negligence, but also under the Equality Act against the university. And the point being, under the Equality Act, was that Mrs. Aberhart was someone with the protected characteristics of a disability because she suffered from social anxiety, which impaired her ability to participate in oral assessments. And she died, in fact, before she was due to give a presentation at a laboratory conference, which formed part of her course requirements. And the claim was brought both at common law and on the basis of direct disability discrimination, indirect discrimination. I've put, that's an interesting point. I've put direct disability discrimination, but I've given section 15 there. That's disability arising discrimination. I apologize for that. That should say disability arising discrimination, indirect discrimination, and a failure to make reasonable adjustments under section 20. And at first instance, Dr. Aberhart succeeded on all three of the Equality Act grounds, but negligence wasn't made out because no duty of care was established. You're familiar, and you will be familiar, that this was appealed before the High Court, and Alice will address you on the High Court decision. But let's be absolutely clear, the High Court decision did not deal with the question of whether or not a duty of care existed, principally because, of course, the High Court decision found that not to interfere with the first instance decision on the Equality Act claims. But there you have, on the top of this slide, the thinking of His Honour Judge Rawlton, and the assessor then, the Equality Act assessor. At first instance, Miss Aberhart did not have the kind of relationship with the university analogous to a school child or a prisoner under its care. Thus, the university had no duty to protect her from herself. Likewise, the university's provision of ancillary welfare support services did not amount to an assumption of a duty of care. And as I say, that issue wasn't determined on appeal before the High Court. The other case is an interesting one, and this is the Feder and McCamish and the Royal Welsh College of Music and Drama. This is a first instance decision in the County Court, but Mr. Recorder Halford in this decision has gone above and beyond in setting out the legal history where duties of care may well be established in the education setting. It's a 160-page judgment, and it is, I do commend it to you as an extremely good reference source for the cases and the authorities cited in it. He held that higher education institutions do have a duty of care to carry out reasonable investigation when they receive allegations of sexual assault by taking reasonable, protective, supportive, investigatory, and when appropriate, disciplinary steps. But the caveat here is how narrow the duty was. The college already had safeguarding procedures in place, and liability only arose because it actually failed to follow its own processes, those that it had voluntarily adopted. And you see now why I make the link between the CUC's assumption of responsibility towards ensuring that sufficient documentation is provided for welfare, and how that crosses over and touches upon the common law duty of care, particularly as identified in Feder and McCamish. If I can ask, go to the next slide, please, Alice. There is in the Feder case a general discussion about a historic, I ought to say, a discussion note in the Association of Managers of Student Services and Higher Education, or AMOSH, which once said that a university has a general duty of care at common law to deliver its education and pastoral service to the standard of ordinary competent institution. That was discredited in Feder. No such common law duty exists, and it is no longer put out by AMOSH, I ought to say. They have corrected the guidance that is there. And if we could move to the next slide, please, Alice, because also discussed in Feder, and actually quite critical to my mind in why Feder reached the conclusion it did, was the case, the Supreme Court case of BXB and trustees of the Barry Congregation of Jehovah's Witnesses. And this touched upon the role of the foreseeability test and whether or not the institution should be liable under a duty of care in the context of a defective investigation of a report of sexual assault. And I'm just going to quote for you Ms. Justice Chamberlain's words at paragraph 178 of that judgment. And that's where the organisation investigated the report of the sexual assault in Mr. Justice Chamberlain's eyes in such a deficient way. This was said, the position of a complainant who claims that she's been raped or subjected to serious sexual assault is unusual. Such a complainant, if she's telling the truth, will already have suffered what is likely to be a traumatic and humiliating violation at the hands of her attacker. Rape and serious sexual assault give rise to psychiatric injury in a significant proportion of cases. Any investigation and hearing conducted to determine whether the assault took place are likely to require the complainant to recall and relive the experience in a semi-public forum. Especially if mismanaged, the process affords opportunities for the humiliation caused by the attack to be repeated and magnified, and for any psychiatric injury to be exacerbated. These basic facts are obvious and should have been so by the early 1990s, even bearing in mind that understanding the effects of sexual assault has advanced in the intervening years. So there you are, and that is why liability was able to be established for the exacerbation as a result of a very poor investigatory process that the organisation undertook. Move on to the next slide, please. Now, in FEDA, there is, from paragraphs 461 onwards, a discussion on the general authorities, mostly those that had been set out in the previous case of Siddiqui. And I'm just going to go through the categories of where duties of care will arise. So the first category in Siddiqui is a claim which asserts a breach of duty owed in tort or contract arising in the exercise by the defendants, that's the university or the college's teaching staff, of academic judgment. An example would be a decision to award a particular grade to a student sitting an examination. Such a claim is not justiciable as a matter of law and is therefore liable to be struck out. Now that's invoking the Clark and University of Lincolnshire and Humberside Court of Appeal decision. The second category in Siddiqui is claims which allege the use of negligent teaching methods in the devising of courses, or the means of acquiring students with the educational content of the courses that are being taught. Those claims can be actionable in principle, and what is your Siddiqui refers the reader to all the cases following the Phelps and Hillingdon London Borough Council decision. And note also the Phelps and Hillingdon London Borough Council decision did engage in a discussion on the necessary assumption of responsibility for the professionals in the case. So because the claimant's attack is on the competence of the defendant's performance in the exercise of skill and care in a profession, the merits of the claim must be assessed by reference to the Bolam test. The third category in Siddiqui is one founded on simple operational negligence in the making of educational provision. Hypothetical advances would include administrative error leading to a student sitting the wrong exam paper, containing questions about which the student received no tuition, or where classes are cancelled due to non-availability of teaching staff. In such a case, if it's proved on the facts, a court doesn't need expert evidence to accept the proposition that the required standard of professional skill and care had not been met. In the Winstanley and University of Leeds case, the further example was given, and that's a contract breach and negligence in which a student's degree supervision arrangements had been found to be unsatisfactory in an internal appeal. If a university fails to take proper care of a student's career by falling short in the delivery of the process involved in obtaining the qualification for which the student is suffering, why is it not arguable that it is foreseeable that the claimant will suffer some loss or injury as a result? And then finally, the case that I've put out there on the slide, the XSA and Surrey County Council. That's a Court of Appeal decision that I commend to you, really to highlight the importance of identifying the facts at the outset, which are alleged to amount to an assumption of responsibility, and the existence, the scope, and the extent of the alleged duty of care. Claimants must identify clearly and concisely what is said that the defendant has assumed responsibility for, and what facts are relied upon as establishing that the defendant has assumed that responsibility. In addition, the claimant should identify the dates upon which the alleged duty arose, and if relevant, the period or periods during which the duty was owed. That's a very brief summary of everything in those authorities. If we can move on to the next slide, please. So, something that was discussed in Federer, and you saw that I predicated it with the in loco parentis comment at paragraph 509, it suggests that no such duty arises per duty. Feder judgment said it's important not to conflate the question of the existence of duty of care with the separate question of what standard of care that duty demands. So when cases refer to teachers standing in the shoes of parents, they're describing the care a child might expect from their parent. That's a description of a standard of care, and in none of the cases do the court say that the origin of the duty itself is in loco parentis. So no separate duty there. We'll now turn to Alice on the anticipatory reasonable adjustments duty under the Equality Act. Thank you, Alice.
Thank you so much. So we've already heard from Lachlan about the county court stage, but of course it was appealed up to the High Court, and it's a very interesting and useful decision, although, as has been already indicated, it didn't go far enough in relation to negligence. But what it did find was relevant to anybody who's practicing in disability discrimination in higher education. So I'm going to go through what it found. So first of all, no, and just to be really clear, no formal diagnosis is required for somebody to be protected under Section 6 of the Equality Act. Constructive knowledge of the effects is sufficient. So it's no longer possible with a reasonable adjustments claim to say that you lack knowledge as a defence to a failure to make reasonable adjustments claim, because that duty is anticipatory. Put out of your mind for the minute the fact that you can use it as a defence in a Section 15 discrimination claim. And this is important because the court found it's no longer possible to rely on we didn't know and we could not reasonably have been expected to know in the context of reasonable adjustments claims. And that is because providers should have thought in advance about adjustments affecting disabled students generally. And this isn't just about, it isn't focusing as heavily on the individual. What it also helps with is knowledge. So knowledge can arise from what is apparent. And the Equality and Human Rights Commission has some useful guidance on what they think about this, because of course they intervened in the High Court decision. But the way they've seen it is that where evidence of disability is apparent from the student's behaviour or language, the provider might have knowledge and can be found to have discriminated. So the question is, what would a reasonable higher education provider, perhaps with trained staff, have understood from the information available about that student? And it's the question of using language from negligence world, foreseeability and reasonableness, rather than hindsight, perfect hindsight. And so if we take a couple of different phrases perhaps that a student says, and have a think about how that might then impact a university's knowledge of disability. So for example, if a student says, I can't physically speak in front of people, that might make you professionally curious about why. If they say, I'm under the crisis team, or I'm having suicidal thoughts, that may raise obvious alarm bells to a professional in that institution. Or if it's, I'm currently freezing and panicking in presentations. These different phrases that a person might use is going to be so fact specific about what has happened in those circumstances. But it's possible that if staff just carried on as if those particular things that were said by the student were just ordinary reluctance, laziness, inability, court might actually go on and conclude that the university has got sufficient knowledge of those disabilities effects. But to be really clear, the standard isn't omniscience. It's what a reasonable provider, with trained staff and the information that's actually available, knew or ought reasonably to know. So it's not a strict liability type test. And that knowledge has got to be assessed in context. So what was actually said, what was recorded, what was clear or obvious from the behaviour, what was the training as well. And if there are any indicators that are vague or ambiguous or genuinely non-specific, then you can imagine that it may be easier to argue that knowledge can't be attributed. But thirdly, the important thing is about reasonableness still governing that duty under reasonable adjustments. So the knowledge is something that may well exist, but the provider is only required to take steps that are reasonable. And that then allows consideration of practicality, resources, academic integrity, and timing. And so it's not about anticipating everything about everyone all at once. It's about potentially categories of disadvantage created by your own systems, responding rationally when warning signs, clear warning signs might arise. And so we can see how this may well be difficult for universities from a governance perspective. And the risk, though, comes from not training staff, not documenting your reasoning, not defining competence standards clearly, or the reasons for those competence standards, not having proper escalation mechanisms, and not perhaps checking with other people about the decisions that you might be making and keeping those things siloed. And I think that institutions that can evidence that they've had those structures, there will be more in a stronger position than universities that don't. So it's a higher obligation. I think it's more clear, it's more demanding, but it's manageable within the structures of universities and higher education institutions now. So what the slide sets out is this point about formal diagnosis not being needed, but it also deals with the question about what happens if an adjustment is declined as well, which will feed into the question of reasonableness. And this was important in the Abrahart case because it was quite clear that staff can't just pass responsibility on to disability services or whatever the higher education institution calls that particular group, and just pass the buck and say, well, you didn't take up that available service. That doesn't absolve the provider making reasonable adjustments simply by passing it on. And that was important because that was an element of that Abrahart case. It also talks about competence standards. So the Equality and Rights Commission has made clear that from its perspective, and again from the High Court's perspective in this case, that methods of assessment will rarely, if ever, amount to a competence standard, and therefore will rarely, if ever, fall outside of the reasonable adjustments duty. And so, just to be clear, competence standard is that standard determining whether someone has a particular level of competence or ability, not the method used to test it. So speaking in front of a crowd of people. And to be clear as well, section 15 discrimination is different. So you can, as a provider, use section 15.2, which would say we didn't know, could not reasonably be expected to know that particular student had a disability, and there's no anticipatory element in relation to section 15, in short. Although a failure to make reasonable adjustments can, of course, render a decision under section 15 disproportionate. So there's a link there on that slide to what the Equality and Human Rights Commission says and how they have clarified those responsibilities. Talks about making sure you've reviewed your processes, have that training, mental health crisis awareness is clear, adjustments required without a diagnosis is particularly in urgent cases. It emphasises not having diagnostic gatekeeping. So not just saying, well, you're not eligible for DSA, so we're not going to do anything. This is particularly important in the context of reasonable adjustments can often have little or no cost as well. The Equality and Human Rights Commission also emphasises proactive inquiry. If they're just struggling or disengaging, being professionally curious about whether disability may be involved, whether adjustments may be required. And again, it goes on to talk about the importance of a clear escalation process and information sharing as well. We then have, again in the background, a new statutory legal duty of care for students in higher education being mooted. It's very much in its early stages at the moment through Parliament, and you can have a look at what Hansard has recorded about this at the moment in the most recent debate in January. I suspect that things will be quieter on the higher education front because of the SEND reforms that were released yesterday morning, but do keep an eye on this. I think and I don't know if Lachlan, you agree, but I don't think we're going to have any real clarity on this very soon, or a statutory duty of care potentially at all. But I'm wondering if you have any alternative takes yourself
I
on whether
fear,
or not
I
you think.
fear that's right, Alice. And in fact, Alice, what that's useful for me to interrupt. There's a request if you could move closer to the microphone, but
Okay, I only have a
I
cold,
also
I'm sorry.
I can hear you perfectly well. So it may be that it will help others who can't just or maybe even just to shout. But no, Alice, I'm entirely with you. Well, there has been a discussion, and there is, and principally led by Dr. Aberhart, but also others. While there is a movement to endeavour to achieve a new statutory legal duty of care, the discussion that took place in January was inconclusive and didn't reach any conclusions. Will there be parliamentary time given the parliamentary agenda generally in education? I suspect not, but what I don't want to do is in any way suggest that continuing to lobby and continuing to put pressure won't achieve the desired result. Um, but there are conflicting opinions about whether the situation is resolved by a further statutory legal duty. But I can't see. Oh, indeed, Alice, you put on the next slide, which is actually a conflicting opinion, which is actually better to create more regulatory reform rather than to create a duty in its own right. But those opinions are out there. But I agree, I don't see the statutory landscape changing in the near future.
So I'm hoping that people can hear me. I will apologise. I do have a cold, so maybe I'm more muffled than I might ordinarily be. What I thought in the last couple of minutes that we would make sure that we touched on was a case involving a higher education institution, both sides anonymised because of a serious allegation of sexual nature against the claimant in this case, and a complainant who also needed to be kept anonymous. And we wanted to talk about this one because it's really important about looking at fairness, procedural fairness in disciplinary processes. So in this case, the claimant was an undergraduate student at the defendant university. A complainant, another person, made serious allegations of a sexual nature against the claimant, which he denied. And then in 2019, in the claimant's absence, the university's disciplinary committee found that the allegations against him were proven on the balance of probabilities. He then brought a claim in the High Court seeking a declaration that he had a right to legal representation and also an order for specific performance to have a further disciplinary hearing. And the judge in their earlier case ordered there to be a further disciplinary hearing. That was in 2019. In 2021, the second disciplinary hearing took place, again in the complainant's absence this time, and the claimant was represented by counsel. Subsequently, the claimant was notified that the allegation had been proven and he was expelled from the university. He then brought a claim, again seeking a declaration of a breach of contract on the part of the university and an order setting aside the decision of the disciplinary committee and the disciplinary appeal committee. And he referred to the university's regulations and contended that the disciplinary process had been tainted by breaches of natural justice, in particular admitting hearsay evidence of the complainant and admitting evidence without an opportunity for cross-examination of the complainant by his counsel. And the university, of course, denied breach of contract. So in this case, what was very interesting was whether or not there had been a breach of natural justice in circumstances where the complainant hadn't attended the second disciplinary hearing. And what did it mean to have admitted that hearsay evidence? What did it mean in terms of the weight then attached to it, and then to have found the allegation proven as a result? And actually, he succeeded in his claim. And on the basis of the High Court's decision, with which the present court expresses agreement, natural justice had required the claimant to have had a full opportunity to defend himself, including by asking questions from the chair. And the reason for the claimant's non-attendance and the steps taken to procure her attendance had been assumed to have been correct, but there was no evidence that they had been examined with any rigour. And on that basis, there had been a failure to question and to be able to question the complainant and breach of natural justice. There should have been opportunity to do that, at least through the chair, not necessarily through counsel, but at least through the chair. And without that, the process had been unfair. And so the conclusion was limited to the fact that the findings had occurred due to the admission of hearsay evidence. And there was an argument that then attaching that they had then attached unfair and unreasonable weight to the complainant's hearsay evidence. And so in the circumstances, without that evidence having been properly tested, it hadn't been possible to find the case against the claimant proven. And there had been, importantly, inconsistencies and contradictions which needed to be tested. So it followed that that second disciplinary committee's decision had been in breach of contract as amounting to a breach of natural justice, and or that it had been unfair and unreasonable. And so too had the decision of the disciplinary appeal committee, which had not corrected the breaches of natural justice to which the present court been referred, as in the High Court in 23. So, and then they said, if we're wrong about that, if the reason given had been sufficient to have amounted to, if there had been a good reason for her non-attendance and sufficient steps had been taken to procure her attendance, they still found that it would have been a breach of natural justice for the hearsay evidence to have been admitted. And the question was whether or not consideration at that present stage was how to give effect to the conclusions of the second disciplinary committee, and whether or not that had then been a breach of contract issue. So in this case, the precise form of relief was to give effect by a declaration, or otherwise that the decision should have had no effect. And if they couldn't agree a form of relief, then they would have to go back to the court to do so. And as far as I'm aware, they did. The claim was allowed. And what this shows is this was a very serious allegation that was made. And some of the policy guidance that I gave earlier was about the importance of not making serious findings about criminal liability. That's not really the university's job. And also particularly where points of law are likely to arise, to actually get legal advice and to allow legal representatives to come along. It also addresses the importance of capacity as well to understand the case. It also addresses important questions about delay. This was a seriously long time. This was the disciplinary committee happening first in 2019 with the allegations prior. And also it's about striking a balance between fairness between the individual and the complainant as well. But this court found that the process had been unfair. And so for these reasons, it's quite a cautionary tale about how to do things. So we leave on the last slide, so here, the question of best practice tips as well. So this is important in relation to information sharing too, and making sure that people receive support through going through these processes, and ensure that there is natural justice applied to these processes as well. So it's now 12:01. We have had a number of helpful and interesting questions in the chat as well.
I'll kick off, Alice, with answering the questions.
Please
you want
do.
to put the last slide up, then everyone knows what we're now doing. Okay, thank you for. We've actually got 4 questions, 1 in the chat and 3 in the question and answer section. Can I just deal first of all with the one in the chat that talks about competence standards? Do you think a requirement to write in an essay format could be a competence standard in, for example, a history degree? And the answer is it may not be. And have a look at the discussion in the High Court decision in Aberhart in that respect. So that was the defence was that the oral assessment was a competence standard, and the High Court rejected that, finding that oral examinations, contrary to the university's contention that they measure the student's ability to convey ideas, were actually a way of testing knowledge and comprehension. So if the point about the essay requirement is to test knowledge and comprehension, then arguably the essay requirement is a method of assessment and not a competent standard. So have a look in Aberhart there. So arguably not. I'm going to say arguably, and this predicates everything we say in answer to questions. Every case turns on its facts, and that's why I'm going to say arguably not. I wouldn't necessarily be able to give advice on a particular essay requirement. I would need to look at the module, see what the module requirements are, see what the purpose of the essay format and what lies behind it, but arguably not looking at the reasoning in Aberhart. The other question in the question and answer section, often see procedural unfairness, public law equality pleaded alongside breach of duty. Is there an obvious overlap link between the two, or is it simply thrown in as an additional cause of action? No, it's not an additional cause of action, but it may very well be something which either defines, if you've established a duty of care under the common law tort, the standard of that duty, or indeed a breach of contract. That's not to say procedure itself is contractual, and using actually a long line of employment law cases, the fact that there should be fairness, particularly in misconduct and disciplinary hearings, would automatically be seen to be part of the process that would undermine any contract if it were not observed. I don't know, Alice, if you want to come in on either of those two questions I've answered.
I was very interested in this idea about the essay. I guess the question is it possible for the university to say the competence being measured as the ability to produce sustained written analytical argument? Which even with, there might be alternative formats, but I can see an argument that doing that orally is going to not give the same output unless you're literally reading something that is of the same amount of detail and content as something in writing. But I think the important bit is about properly exploring those alternative formats and whether they could properly measure that competence. So it wouldn't just be a blanket history degrees require essays, therefore no adjustments. But whether or not with like extra time, assistive technology, different type of quieter environment, maybe doing the drafting in stages, something like that would be a different mode of doing it to demonstrate the same standard. And I also think that questions have become a lot more difficult with how essays are going to be written at the moment anyway, with the existence of AI tools anyway. So probably seen possibly a return to the more organic pen and paper and oral assessment of arguments anyway, because of not being able to trust the fidelity of what is produced in writing anyway.
Right, just very quickly then, because I'm conscious of time, the other two questions that exist were, in fact, the first two questions asked in the question and answer panel. I'm going to deal with the second one first. This is the OIA. What relevance does the OIA have, bearing in mind it's not the determiner of discrimination? Absolutely right. In the Maxwell case, it found, but query, did it need to find? In fact, the Court of Appeal were just actually upholding the earlier decisions that the OIA is not responsible for findings of discrimination. And I see no new law invented there by the Court of Appeal, but it does helpfully summarise it. The issue for the OIA, said Lord Justice Mummery in that case, was not to decide whether Ms Maxwell was in fact the victim of disability discrimination or whether the university is liable to her for such discrimination. The OIA's task was to view Ms Maxwell's complaint, which included complaint of discrimination, to see whether the university's decision was reasonable in all the circumstances and was justified, and if so, to what extent, and what recommendations should be made to the university. So let me just answer the question, what relevance, briefly in this way. It's relevant because the OIA is still out there. It is still performing a service, and it is still enabling the way in which complaints are handled to be subject to independent scrutiny. That's the relevance. Clearly, it's not the determiner of discriminations. Um, I'm just going to very quickly deal with the first question asked, which is many universities still not feel anticipating providing for disabled students' needs. We can't anticipate everything, so we won't. And still engaging in behaviour that's akin to the conduct that's found to be illegal in the terrible Labour Hart case. What can be done to combat such continuing conduct? Sort of hope, in fact, I know we will have answered this by giving you this presentation. What can be done is by pursuing the channels and using the guidance and the advice that this presentation has provided. What I think is important is each case will turn on its own facts, and I have no doubt there will be some universities who will take issue with the suggestion that they're not doing everything or they're not doing sufficient in order to anticipate the duties. But again, each case turns on its own facts. But I hope you have found the presentation of assistance to how you, the word combat is not the word that I would use, it's how you challenge, it's how you bring about a resolution in a case on its particular facts. I hope the presentation has been of assistance in that regard. Alice, if you have anything further to add, please do.
No, the only thing I was going to say, or two things I was going to say. First of all, we have our next webinar that is coming up on the 12th of March, and that is all about damages and remedies in the higher education claims, and that's at 11 o'clock on the 12th of March with our wonderful colleagues Charlotte Hatfield and Alex Leonard. I also am doing a seminar this evening at 6 o'clock on the SEND reforms, which there will be an email reminder of if you are on our mailing list, and it's also being advertised on LinkedIn, and that will probably affect some of you who have kindly attended today. The seminar has also been recorded, and of course the slides will be available afterwards. There have been some, if our questions, if your questions haven't been answered as well, please feel free to email us. Well, we'd be delighted to help. But I think that's everything for me. Thank you so much.
Thank you, Alice. Thank you, everybody.